next, we have Richard Halpern. Again, many of you probably in this room are familiar with Richard and his work. But for those of you who are not familiar, or for some of you online who may not know about Richard, Richard is a senior lawyer acting exclusively for injured people in medical negligence cases. He has a special focus on infants, and he calls them his babies, that are injured at or around the time of birth. Richard is known across Canada for his expertise in birth injury cases. He has more than 30 years of experience representing seriously injured people. His experience allows him to provide meaningful advice and direction to families considering a medical negligence lawsuit following a review of the medical records. It's my pleasure to welcome Richard to the stage to speak about causation, a case study.
Thanks, Brenda. Charles, that was a great talk, and I'm not sure if it's more exciting or more frightening to hear about that sort of stuff. But we can imagine how, from a medical malpractice perspective, standard of care is going to change in the cases that we do. And we have to be mindful of the developments that Charles spoke about and adjust our thinking about standard of care. But maybe even more interesting is the impact it's going to have on causation, which is what I'm here to talk about. The technology changing, I think, is going to change how we think about causation. Now, I know a lot of people in this room, we have a mixed crowd. We have lawyers and we have healthcare providers. And much of my talk is really aimed at our legal understanding of causation. But it applies to all healthcare providers who get involved in legal cases, because you must know causation. The thing with causation, insofar as science is concerned, is that you need to understand that as people concerned with science, you have to adjust your thinking about causation, because at law, we think about causation in a different way than scientists think about causation. So for science, the test may be a 95% confidence interval before we will make a connection between an event and an outcome. At law, the test is much more relaxed than that. It's called a balance of probabilities, just greater than 50%. Scientists must have that in mind when they're thinking about causation in their cases. The other thing is the difference between correlation and causation, I think, is important. Correlation, insofar as science is concerned, is insufficient to make a connection between an event and an outcome. But for law, correlation is enough. That is, if harm B follows event A, so that there's a correlation, but not necessarily strong proof of causation, it may nevertheless be causative at law. It is permissible for a judge or a jury to make a causal connection based on evidence of correlation alone. A very important concept. So I'm going to talk about how we get there. So the first thing we have to understand is, what is causation? And we need to know where causation fits into the negligence analysis. So let's start there. Let's get to the fundamentals, because I think it's very important. At law, when somebody wants to make a claim in tort, the first thing they have to do is establish that the wrongdoer, in our cases, doctors or nurses, owed a duty of care to the patient to take or do certain things or not to do certain things. That's a duty of care. That's the first step. That has nothing to do with causation. Did the doctor owe a duty of care to the patient? If the answer to that is yes, and by the way, that's a legal question for a judge, not for a jury, the next question that must be asked is, did the doctor or did the nurse breach that standard of care? So the plaintiff must demonstrate, the patient must demonstrate, that the nurse or doctor failed to meet their obligations towards the patient. Once that is done, we ask the question of causation. Is there a connection between the harm that the person suffered and the conduct or the omission, act or omission of the doctor or nurse? And that is causation. And causation is a factual issue, but it is very poorly understood. I'm going to go through some cases to demonstrate that even our courts continue to get the notion of causation wrong, and it's a problem for all of us, for litigants and parties. So as I said, it's a factual causation, and it merely asks whether there is a link between an event and an outcome. That's what it asks. Is there a link between an event and an outcome? So here the conduct of the doctor or the nurse and the harm suffered by the patient. Now, in law, there's a test for causation, and it is called the but-for test. So generally the question is asked, but for the breach of the standard of care by the doctor, would the injury to the patient have been avoided? That's the but-for test. But for the conduct, would the injury have been avoided? The problem is that but for is the label that is used for this test, but it tells us nothing about how the test is to operate in real life. So if I'll give you just a quick example, if you're driving your car down the road and you fail to apply your brakes and you smash into the car in front of you, you can say that had you applied your brakes, the collision never would have occurred. It's a hypothetical question because the collision did occur. Okay, so but for is a question that's asked in a hypothetical situation. Had you applied your brakes, would the collision have been avoided? Well, the answer in that scenario is obviously yes. But for your failure to apply the brakes, the accident would not have happened. So it imagines this hypothetical world, and the same thing in medical malpractice. Had the nurse turned off the oxytocin during the labor, would this baby have avoided neurologic injury? That's what we have to prove. That's causation. In these cases, the issue is how do we prove it? So this brings into this, which is really a philosophical notion of something called the counterfactual. The counterfactual merely says, let's ask a question that runs counter to the actual facts. I apply the brakes. Had I applied the brakes, I don't collide. That's called a counterfactual. And the notion that I'm trying to get across is that we have to look at the foundation of the but-for test having its provenance in the counterfactual if we're going to ask the correct questions. Now, it's easy in the rear end car accident where I don't apply my brakes, but where we get into more difficulty in medical malpractice litigation is where there are multiple events that cause the outcome. How do you ask the question when there are multiple events? So sometimes the wrongful act isn't the only event. I'm going to look at some cases where the wrongful act is not the only event that brings about the harm. And sometimes there are what I call guilty events and innocent events. In other words, there may be some things that are required to bring about the harm that aren't caused by anybody's negligence, but they may be occurring with other events that were negligent. And how do you sort through those multiple events where some are innocent or some are guilty? And this is really a shortcoming in our law that hopefully will be corrected sometime in the near future. So if we're going to ask, I call it a properly framed counterfactual question, but a properly framed but-for question. We can interchangeably, I think, use but-for in the counterfactual. A properly framed causal question must ask a question that allows negligence to be found where it exists. So the classic example in medical malpractice cases is, say, a delayed diagnosis case where the post-op patient is in the recovery room and the nurse doesn't appreciate all the problems. And then the resident comes in and doesn't do a thorough exam. And then the staff doctor comes in and orders a blood test, but it takes too long to get to the lab. And then the lab fails to report the blood test back to the doc. And by the time all of these things happen, guess what? Bad news. And we have some cases like that. You have to have all these things, all these events in the chain to make the causal connection between the individual's liability and the outcome. And it's a very difficult question to ask. So our law right now does not adequately provide for this interplay, in my view, between innocent and guilty causes. And the leading case is a Supreme Court of Canada case from 2012 called Clements and Clements. I think it's an unfortunate decision of the Supreme Court of Canada. I've written a critique of it. I think that it's really led to a lot of problems in terms of how we approach causation, but that's subject for another day. So it's not advancing for some reason. There we go. So I'm going to talk about a few cases to illustrate what I'm talking about. This is a recent case from the Ontario Court of Appeal. This is a lady who had a congenital heart defect. She had what's called a coarctation of the aorta, which is a narrowing of the aorta. And throughout the lives of these people who have coarctation, they periodically need cardiac intervention. So she is having surgery to fix her coarctation, and the times I think are important. But what happened was during the procedure to fix her aorta, there was a rupture. And the interventional cardiologist was working on her, and they tried to control the bleeding that was associated with this rupture. So somebody, I think a nurse, alerted the cardiac surgeon that there was a problem, and 2 times the cardiac surgeon came in to see the patient and was sent away, was dismissed, saying, "Don't worry, we have this under control. We don't need the cardiac surgeon." The interventional cardiologist then inserted a stent to control this woman's hemorrhage. Again, not thinking that he needed any help from cardiac surgery. So the stent is deployed at 11:28, and these times are going to be very important. And after they inserted the stent, the cardiac surgeon still isn't called, and this woman is extremely unstable, obviously hemodynamically unstable at 105. At 14:20, the cardiovascular surgeon is finally involved. And by the time the cardiovascular surgeon gets there, the patient has suffered paraplegia, anoxic brain damage, and other injuries, all due to ischemia from the lack of flow from the aortic bleed. So the two doctors involved before the cardiac surgeon were called were found liable, and they appealed on the issue of causation. So the plaintiff claimed that it was the delay in getting the cardiac surgeon involved and getting her back to the OR that caused her injury. But this is an example of what I call innocent and guilty causes. So we have to think about the rupture of the aorta as being an innocent cause. It was a risk of the repair of the coarctation. So that's an innocent cause that could have caused death or disability all on its own. Keep that in mind. It could have caused death or disability all on its own. It would have interrupted flow down the aorta to the organs into the spine. So flow downstream is interrupted by virtue of the innocent cause. The plaintiff claimed that the neuroimaging, and Charles was talking a little bit about neuroimaging and AI interpreting neuroimaging. That may be a very important tool in these cases, but the plaintiff alleged that there was a watershed injury to the brain, which is an injury that occurs as a result of systemic hypotension. So a lack of circulation to the brain, which causes a bilateral watershed kind of injury. And that's important because we're going to see the defense had a completely different interpretation of the imaging, incompatible with what the plaintiff had to say. The defense said that that there were emboli that caused the brain injury. So there was focal injury like stroke that caused, because after the cardiac surgery, because one of the risks of the cardiac surgery is the generation of these emboli that can cause focal injury rather than the watershed sort of diffuse injury that the plaintiff claimed. So they said there were embolic infarcts rather than a watershed injury, and that the assertion by the defense was that the plaintiff has failed to prove causation. When did the injury occur? Before or after the surgery? They asserted that the negligence was only a mere possibility. You can't win a case on causation merely on possibility. The burden of proof is heavier than that, and therefore the defense alleged that the plaintiff did not meet the burden of proof. So in order to determine whether or not causation is made out, there needs to be a finding about when the injury occurred. Well, how can you know when the injury occurred? The plaintiff is bleeding from the innocent cause and is hemodynamically unstable from the guilty cause being after the delay in getting the cardiac surgery involved. Which caused the injury, the innocent cause or the guilty cause? Well, it's both, isn't it? I mean, the plaintiff is never exposed to injury from the guilty cause unless the innocent cause happens first. That rupture of her aorta had to happen before the guilty cause had any role in causing the outcome. So how do you reconcile these two things? How do you determine when it occurred? Well, nobody could say with precision when this injury occurred. And therefore, it's left to a judge and a jury to infer when the injury occurred. And one of the dynamics at play here is one of the reasons we don't know when the injury occurred is because of the negligent act of the defendants. So the defendants were found to have breached the standard of care by not getting cardiac surgery involved and deprived the plaintiff of the opportunity to prove precisely when the injury occurred. Had they intervened and called the cardiac surgeon and the plaintiff was uninjured, they would have known that it wasn't the innocent cause. Had they brought in the cardiac surgeon in time and the plaintiff was still injured, they would have known, right, that it was the innocent cause that resulted in the harm. But because the defendant's own breach of the standard of care prevented the intervention that we say needed to avoid harm, we can't know for sure. So an expert testifying couldn't know for sure, and the expert didn't know for sure in this case. This is what I'm talking about when I talk about the difference between correlation and causation. It is permissible for a judge or a jury to infer from that evidence either way. And once they've done so, it is a fact. Once they've done so, it's a fact. So in this case, that's exactly what happened. So here, what the judge said was, after hearing all that evidence, the possibility of injury before, the possibility of injury after, the watershed injury that establishes the plaintiff's case, the embolic injury that implicates the surgery, after all these things occurred, the judge said, I'm satisfied on a balance of probabilities that it was the failure to call the cardiac surgery team in time that caused the outcome, as is permissible. So the test is a balance of probabilities more likely than not. And the judge applied the but-for test. What was the but-for test in this case? Had they called for the cardiac surgery team earlier, would the injury have been avoided? So but for their failure to call the cardiac team earlier, this injury would have been avoided. That's the test, the counterfactual. I hate calling it the but for, I call it the counterfactual. So what affected this decision? There was significant blood loss immediately following the rupture, and they used a balloon tamponade to stem the flow of the blood. There had to be some diminished perfusion already downstream from the innocent cause. There had to be. But according to the judge, that wasn't the problem that caused the outcome. It was that the patient remained hemodynamically unstable. The patient was in hemovolemic shock, and the surgery, the risk of the surgery was a greater risk for the injury than the balloon that was initially put in. Okay, so those were I'm going to just skip through. Right, so this notion of inference and common sense is something that I want to talk about. It is unlike scientific proof of causation at law. It is, you can infer from all of the evidence as the trier of fact, a judge or a jury, you can infer causation. based on the evidence, and you're allowed to invoke some notion of common sense. Not sure that common sense is all that common, but you can do that. So was this a mere probability? Not according to the judge. It wasn't a mere probability. The causal connection was made. And there is some law that talks about, when we talk about causation in medical malpractice cases, we talk about this notion of a robust and pragmatic approach to causation. And that comes out of a Supreme Court of Canada case in 1990 called Snell and Farrell. I think the significance about this robust and pragmatic approach is based on the idea that often the means of proof in a medical malpractice case aren't available to the plaintiff. If you're having surgery and you're under general anesthetic, you can offer no evidence about what happened, that for what went wrong. You have no evidence. And so the courts recognize that the plaintiffs are at a disadvantage in these things and invoke this robust and pragmatic proof to causation, so that very little scientific evidence is needed to get over the threshold of proof. Very little scientific evidence is needed to get over the threshold of proof. And absent a more cogent explanation by the defense for what happened, the plaintiff can succeed. Recognizing the challenges that plaintiffs face in medical malpractice litigation. So very little scientific evidence will get them over the threshold. But remember, this doesn't mean that it's easy to prove causation. First of all, the burden of proof is on the plaintiff to prove causation, and that the plaintiff must call all the evidence there is to call on causation. In other words, having this robust and pragmatic approach does not excuse the plaintiff from proof and from calling all the evidence that is within their power to call. It's only when all of the scientific evidence has been called, that could have been called, that a trier of fact is then allowed to invoke inference and common sense from the totality of the evidence, but it must be based on the evidence. So what are we missing? The court really didn't talk about innocent versus guilty in this case. I would have preferred that they did. But both the innocent cause and the guilty cause were required to bring about the harm in this case. Now, sometimes we think about the but-for test as a test that requires the harm to be necessary to cause the loss. But necessary is a very unfortunate word when it comes to causation. You can see that there are scenarios where the cause is not necessary, but yes, yet implicated in the harm. So let me give you an example. An example is there are two raging fires, both negligently caused. Each fire would be enough to destroy the plaintiff's property. But before the plaintiff's property is destroyed by fire, the two fires merge and then destroy the plaintiff's property. And the question is, but for fire A, would the loss of the property been avoided? Well, fire A wasn't necessary because fire B occurred. So fire A is not responsible for what happened. Okay, well then what about fire B? But for fire B, would the loss have occurred? Well, no, because fire B wasn't necessary because fire A happened. So how do you ask the counterfactual question? Because if you ask it that way, you find that neither fire A nor fire B caused the loss. Well, that can't be so. So we must think about how we frame the counterfactual question to tease out the role that each of fire A and fire B caused in causing the loss. The correct question, incidentally, is, had fire A not occurred, with or without fire B, would the loss have occurred? Right? It's only that way that we can find causation where we know causation to exist. Bit of a complicated concept, but something that's important for medical malpractice cases. And this deals with sufficiency as well. One cause may be insufficient. Think of the delayed diagnosis case, where the nurse doesn't examine the patient in the recovery room. But that wasn't enough to cause the plaintiff's injury because the resident made a mistake, and then the MRP made a mistake, and then the lab made a mistake. They were all necessary, each one not on its own sufficient, to bring about the loss. So we have to think about that when we're thinking about causal questions. Okay, so this is what I say is a defect in the Clements and Clements case. Okay, I'm quickly going to run out of time because I don't want to get into the next, I have 5 minutes. So let me just talk about Fellows and Farage, which is a birth asphyxia case. And this is a case where a woman, again, the timing is really, really important in this case. Woman presents at 23:01 to Dr. Fellows with evidence of uterine rupture. He actually diagnoses a placental abruption, although he says that uterine rupture was on his differential as well. And the fetal head was high, so delivery was not imminent. And then within 3 minutes, there's a severe fetal bradycardia. So obviously the baby is in serious trouble. The heart rate is low. The baby is at serious risk of getting neurologic injury. And Dr. Fellows decides to rupture the membranes, where he finds a lot of bloody fluid, amniotic fluid. He, as I said, he suspected a placental abruption with rupture on the differential diagnosis, and he opts to do a forceps delivery rather than an immediate cesarean section. So 23:07, there's a large gush of blood. He at that point realizes that in fact the diagnosis is probably a uterine rupture and not an abruption. He applies the forceps and he delivers the baby at 26 minutes after mother presented to hospital. So on causation, the plaintiff calls a neonatologist and who says that he doesn't know exactly when the baby got hurt. Nobody can know. The baby's in the uterus. There's obviously a problem. The baby's exhibiting issues. How do we know when this baby got hurt? So what the plaintiff says is, well, the earlier the baby's in so much trouble, the baby's deprived of oxygen, the earlier you get in, obviously, the better the outcome is going to be for the baby. That's their argument. Their case is that the injury occurred no earlier than 2015 and as late as 23:25. They say that a C-section should have been done in 8 to 10 minutes. And the defense said that the brain damage could have been done by then, that the injury was unavoidable, even if a C-section was done. And because the plaintiff's expert was unable to say definitively when injury occurred, the plaintiff fails on causation. Well, again, it's through no fault of the plaintiff that he or she can't prove scientifically exactly when the injury occurred. It's not their fault. And so it's open for the court to infer. So here there's a uterine rupture from a non-tortious cause. So we now have an innocent cause. And the baby was obviously oxygen deprived. But babies who are oxygen deprived in the uterus aren't necessarily injured. The lack of oxygen in the uterus may be hypoxic insults. Term babies are very resilient and have some capacity to withstand these hypoxic insults before that insult converts to injury. The judge correctly identified the issue, and we're going to be talking about with Justice Wilson about these things. So I'm going to leave cause or material contributed out until we talk to Justice Wilson. What ultimately happened in this case is that the Court of Appeal said that because the trial judge didn't identify precisely what difference a C-section would have made had it occurred, that she failed to properly address causation and a new trial was ordered. Very quickly, very quickly, just for 1 minute, this is an accident benefits case. It's a case where the plaintiff wanted to prove that a third car accident had pushed the plaintiff over the threshold of catastrophic injury. Right, so it was a claim against the insurance company for a catastrophic injury designation so that the plaintiff would get enhanced no-fault accident benefits. And this is a case that says Ontario Court of Appeal. It's actually not the Court of Appeal, it's the Divisional Court. But this is a decision of the Divisional Court where the court completely botched the notion of causation. A recent case that demonstrates that the courts continue to get the causation issue wrong. And in this case, it was clear that the Divisional Court actually fundamentally misunderstood the notion of causation in this case. So they say, for example, they say that generally the but-for test is preferred. And by saying so, they imply, well, there's some other test for causation. And I want to suggest to you that there's only one test for factual causation in tort law in Canada, and that's the but-for test. There's something called a material contribution to risk test, but it is not a test of causation. So that's Clements and Clements. It is not a test of factual causation. I don't have time to get into why it isn't. Okay, so just another day we'll talk about that. And there are circumstances where it, referring to the but-for test, will not provide a satisfactory answer. We're not looking for a satisfactory answer. We're looking to solve the causation question. Satisfactory answer translated means I don't like the outcome with how I've applied the but-for test, so I'm going to do something else. That's not principled. I don't have time really to get into it, except to suggest to you that the divisional court, for example, say the facts of that case fit comfortably within the exception to the but-for test. When they're talking about the exception to the but-for test, we're talking about this notion of material contribution to risk. It doesn't fit at all with the notion of material contribution to risk. This was just a claim against a single entity, an insurance company, not even a tortfeasor. It was a contractual claim. And the only issue is whether or not the plaintiff met the definition of catastrophic. So I'm going to stop there because we have a very important guest who's waiting.